Hello friends, how are you? I hope your preparation is going well. My name is Mohammed Yunus and today I'm going to discuss with you what is the difference between articles 31A, 31B and 31C. These three are very important articles, but I have come across so many aspirants who are not sure about the difference between these three articles. In order to understand these three articles, you need to understand how these three articles evolved in the first place. So I will briefly explain that and then I will talk to you about the difference between these three articles. If you like the videos that I make, then please share and subscribe the video. As well as there is a link to the Telegram channel in the description. Please join that. I promise you that it is not just another Telegram channel which will contain different materials. No, here I am going to just solve your doubts, both academic as well as non-academic, with respect to UPSC exam preparation. And you will not regret joining that channel. Let us start with the video. In order to understand the evolution of Articles 31A, 31B, and 31C, you need to understand two important things. Since the beginning of the Constitution in 1950, continuous battles have been fought between two different subjects. One is between the Supreme Court of India and Parliament of India. If you have read polity, then you know that both Supreme Court and Parliament have been continuously fighting over whether the Constitution can be amended and how much of that can be amended. And in this battle, Supreme Court has evolved one of the important principles in the Indian jurisprudence, and that is called as basic feature doctrine or basic structure doctrine. Another battle that has been going on since 1950 between fundamental rights and DPSPs. There are two terms which are very important. One is individual good and second is common good. Individual good means anything which helps increase the welfare of individual is called as individual good, and anything which serves the community as a whole is called as common good. Let me give you one example which will help you clarify what is the difference between individual good and common good. Let's say in your home you have a borewell, right? Now this borewell will supply water to your home. So this is individual good. But if the government builds a big well or a big lake in your town, then that lake will supply water to the whole society living there, right? And this is an example of common good. So individual good in the Constitution of India are given in part 3, which is fundamental rights, and common good is given under part 4, which is DPSPs. So basically DPSPs try to promote social welfare or common good. Basically there were two problems in India in 1950, and one of the important problems was the condition of rural economy and agricultural sector. Peasant condition was pathetic, and most of the peasants, in fact 99% of the peasants, were small and marginal, and most of them did not have right to the land they were tilling, right? And why this condition was there? In order to understand that, we need to go back to 1793. In 1793, what happened? 1793 में Lord Cornwallis undertook an important policy decision, and that was called as, what was that called? Yes, it was called as permanent settlement, right? Under permanent settlement, what British government did was it took away the land rights which were present with the peasants. The peasants who were cultivating their land for thousands of years, their land was taken away from them and it was given to a new class of intermediaries called zamindars. Now suddenly overnight, peasants became completely landless, and their oppression began from then on, right? And it continued till 1947. And in 1947, most of the land in rural areas was owned by zamindars, right? And in order to increase the condition of peasants, one of the most important assets that they need is land, right? And this was one of the main aims of the Constitution of India as well as the new government, that is provisional government. They both wanted to give land to peasants. And how that can be done? By taking away land from the zamindars and giving it to the peasants. But it was not an easy job. Now, how to do that in 1950? Several acts had to be passed by the Parliament of India as well as state governments in order to do that. This was the first issue. Second issue was a lot of natural resources which were present in India were in private hands, right? And what was the intention of the government? Government wanted to take away that from the private hands and nationalize those resources like mines, banks, and all, because they were not serving the common good. They were serving the individual good. And India was already suffering from resource crunch because of the 200 year of exploitation by the British government. Resources were lacking in India. There was poverty, backwardness in rural areas. In order to deal with these three, Government of India adopted socialistic principle, and according to that principle, government should command the heights of economy. Commanding heights of economy must be with the public sector. So these were the two most important issues, and which led to the beginning of Articles 31A and B. Let us see how that happened. Now, I just told you that both Parliament and state governments wanted to take different Zamindari abolition acts in order to give land from Zamindars to peasants. One of the acts was abolition of Zamindari. So basically, both the national government as well as state governments wanted to abolish Zamindari so that land can be given to peasants. Second was create land ceiling and give extra land to peasants. Next is utilization of vacant and wasteland. A lot of vacant and wasteland was under the ownership of zamindars in rural areas. Government wanted to use this vacant and wasteland for building public infrastructure, right? And nationalization also began. For example, Air India was nationalized in 1953. Fine. Now, the question was how to take away this private property of the zamindars and give this land to the peasants, right? Government wanted certain authority to do so. And this came in the form of two important legal principles which are used in other countries in order to take away the land from the private owners and give it to the others for public purpose, right? And let us see what are those two legal principles which are used. The first legal principle is called as eminent public domain. I'm sure you must have heard this in newspapers or in NCRT. Now, second principle is salus populi suprema lex. Let us understand one by one what is eminent public domain principle. Basically, this principle has been adopted from American Constitution. What does it say? Any state can take away private property of individuals if it fulfills three conditions. And what are those three conditions? Private property can be taken only for public purpose. For example, government may take away private property for building dam because dam will benefit society as a whole, right? So only for public purpose. Second condition is that private property can be taken only under the authority of a law, meaning simply the government of India or state government cannot do it. State legislature or parliament can enact a law which will take away the private property for public purpose. Third, if private property is taken away from the individuals, then they must be provided with just compensation. And this was the principle which was eminent public domain, right? Now, Government of India introduced this principle of eminent public domain in Constitution of India. In the next section of the video, I will tell you how that has been included in the Constitution of India, right? Second principle is salus populi suprema lex. This can be asked in prelims and mains exam and other competitive exams, so please remember this. What does this principle say? This principle is a Latin phrase which says that common good is superior to individual good. Meaning, if any action is being taken by the government for promoting societal good or common good, then that is superior to individual good. Meaning, it says government can take away private property for promoting societal good. So these two principles were taken by the Government of India and inserted them in the Constitution of India, and let us see how that was done. Right to property is not a fundamental currently, right? It is not a fundamental right. It is just a legal right which is given under Article 300A. How did this happen? That requires a separate video. I'm not going into details of that. But before 1978, before the 44th Constitutional Amendment Act, there was right to property in Indian Constitution, and that was fundamental right. And which were the articles which gave this right to individuals? Article 19, right? In Article 19, there was one article called Article 19(1)(f). This article gave fundamental right to property to every individual in India. What did it say? It said that every individual has right to acquire, hold, and dispose of property. But at the same time, as I told you in previous section of the video, Government of India wanted to give right to the state to take away this private property from individuals in order to fulfill public purpose, right? Now, how that was done? Another article was inserted in Fundamental Rights chapter called Article 31. And what did Article 31 say? Article 31 said very simply that state can take away private property from the individuals after fulfilling three conditions. And what were the three conditions? I'm sure you can guess it. Those are the conditions that are given in the principle of eminent public domain. And what are those principles? That state can take away private property for public purpose only through a law and by giving compensation. So this article, that is Article 31, helped the state to take away lands from zamindars, right? However, zamindars were not going to sit silent and watch this, right? Zamindars were ready to approach the courts in order to challenge their private property being taken away. And how that happened is a history of the evolution of Articles 31A, B, and C. Let us see that. Now, one important fact that you need to remember is that acquisition and requisition of property, that is taking away property for public purpose, is given in concurrent list. So if a question comes in prelims, you need to remember this, right? It means also that both Parliament of India as well as state legislature are capable of acquiring private property for public purpose, right? When constitution was implemented, both the parliament and state governments started undertaking land reform acts to deal with zamindari abolition, right? And as I told you, zamindars were ready to approach the court against this. One of the important legislations which was undertaken by Bihar government. Now, why am I choosing Bihar government's legislation? Because this was the Land Act which led to the creation of Articles 31A and B. Let us see how. So, Bihar government undertook Bihar Land Reforms Act. This legislature was to take away land from peasants for public purpose. Now, in this act, Bihar legislature has said that if the land of big zamindars is taken away, then big zamindars will be given compensation which is 3 times the market price. However, if the land of small farmers is taken away, then small farmers will get compensation which is 20 times the market price. Now, zamindars took this to the Patna High Court. What was their contention in Patna High Court? They are saying that if Bihar Land Reform Act is taken away our private property, then it is fine. If Bihar government is using our private property for public purpose, then it is fine. Okay, but we have problem with this kind of compensation because Article 31 promised us compensation, but you are discriminating between these two types of farmers while giving compensation. And they said that because of this discrimination, Bihar government is violating Article 14 of the Constitution, which prevents discrimination. And they took this case to the Patna High Court. And the name of this case is called as Kameshwar Singh case. And this is a very important case in the constitutional history of India. Now let us understand what happened after that. Now, as I told you, zamindars took the Bihar Land Reform Act to the Patna High Court, and the name of the case is Kameshwar Singh case of 1950, right? And in Patna High Court, they argued against the violation of Article 14 by giving less compensation, and they also said that this act also violates Article 19 because fundamental right to property has been given under Article 19. Now, what happened? Patna High Court rejected their claim under Article 19 because Patna High Court said that though you may have fundamental right under Article 19, but government or the legislature of a state has right to take away your property by giving you the compensation under Article 31. But Patna High Court said that legislature of Bihar is not doing just thing because though compensation is being given, but that compensation is less compared to the one given by legislature to the small farmers. So this is discrimination and this violates Article 14, right? So that is why Patna High Court struck down Bihar Land Reform Act. Now, what happened because of this? The state governments as well as government of India were shocked. Why? Because now the whole agenda of land reforms was derailed, right? Because this was a cue to other zamindars in other states to approach the courts under Article 14 and 19 and ask for the striking down of various land reform acts being undertaken by different states. And this was not good for land reform agenda of the government of India as well as government of states. Right? Now, Bihar government, in order to help deal with land reforms, took this case to the Supreme Court of India, which was newly established. Right? Now, Supreme Court of India also took the view taken by Patna High Court. You have to give same compensation to big zamindars as well. Otherwise, you will be violating Article 14 and 19. That is why the act is wrong. Right? So, Supreme Court also struck it down, and the case is known as Kameshwar Singh case. Now, in order to deal with this problem created by the courts, the newly created parliament amended the constitution. And this amendment is important to understand the evolution of Article 31A and B. Let us see what is that. So, the Parliament of India introduced the first Constitutional Amendment Act. Now, first Constitutional Amendment Act is important for other reasons also, but this first Constitutional Amendment Act introduced two new articles in the Fundamental Rights chapter. And these two articles are called 31A and 31B. Okay. Now, what did 31A say? If you go and read the 31A article right now, then it says one important thing, and that is if any act taken for land reforms and nationalization of resources, then these two types of acts cannot be challenged in any court for violation of Article 14 and 19. You see, Bihar's act was struck down because it was violating Article 14 and 19. Supreme Court also took the view. So, in order to prevent future challenges to any such land reform acts, it was clearly stated in Article 31A that such acts cannot be challenged for violating Article 14 and 19. Now that government inserted Article 31A, which will protect any future land reform and nationalization act from being challenged for violating Article 14 and 19, Parliament wanted to be extra cautious, right? Now, Parliament thought if the zamindars can challenge these acts in the courts for violation of Article 14 and 19, then any future legislation which is trying to promote social welfare or trying to implement DPSPs can be challenged, okay, in the courts for violation of Article 14 and 19, meaning any act, not necessarily Land Reform and Nationalization Act, any social welfare act. Also, that they can be challenged not only for violation of Article 14 and 19, they can be challenged for violating other fundamental rights, right? So, in order to make sure that such things do not arise, Government of India, through the Constitutional Amendment Act, proposed to include one more article in Fundamental Rights chapter called 31B. And what is Article 31B says? Article 31B basically inserted a new schedule into the Constitution called Schedule 9. Okay. And it said that any act passed by the Parliament or the state legislatures, right, need not be just land reform or nationalization, any act. If that act is put in Schedule 9, then such act cannot be challenged in any court for violation of any fundamental rights. So, government undertook a preemptive action to protect social welfare legislations from being challenged in any court for violation of not just 14 and 19, but any fundamental rights. Right? Now, let us understand just in a chart what are the differences between Article 31A and B. As I told you, 31A is narrow in two senses. One, it deals only with Land Reform Acts and Nationalization Act. Okay. And 31B is broader, right? It not only restricts itself to just land reform and nationalization, but any act which is inserted in 9th schedule. What is the second difference? Second difference is that such acts cannot be challenged in court for violation of Articles 14 and 19. Only Article 14 and 19. So in this sense also, 31A is narrow. But 31B says that any act which is put in Schedule 9 cannot be challenged for violation of any fundamental rights. So 31B is broader. However, this broad character of 31B was clipped by the Supreme Court in many judgments. In 1973, in Keshwananda Bharati case, Supreme Court evolved one of the best principles in India's jurisprudence called basic structure. Any act which is put in 9th schedule after 1973, that is the date of Keshwananda Bharati case, it cannot violate basic structure. Fine. So the wings of Article 31B were clipped, right? Earlier, it could not be challenged for violation of any fundamental right. Supreme Court said, okay, but it cannot violate basic structure of the Constitution. Then came the second case, Vaman Rao case in 1980. Vaman Rao case may be Supreme Court said the same thing, that any act which is put in 9th schedule under Article 31B after 1973 cannot violate basic structure of the Constitution. But the wings of Article 31B were clipped very much in IR Coelho case. Supreme Court said not only basic structure, any act which is put in 9th schedule after 1973 cannot violate 14, 15, 19, 21 as well. So basically, this was made narrower than Article 31A. Now, having understood the evolution and significance of Article 31A and 31B, let us understand how the Article 31C came into being. And after that, we will see the difference between these three. Now, as I told you, Government of India wanted to promote common good, and it was taking different actions for promoting common good. And one of the actions undertaken by Indira Gandhi government in 1969 was she nationalized suddenly 14 banks. These were private banks, and overnight these banks became public sector banks, right? And that was through Bank Nationalization Act passed by the Parliament of India, right? But Bank Nationalization Act was challenged in the Supreme Court for violation of Articles 14, 19, and 31. Now, before understanding what was the contention of the bankers who owned these banks, let us first understand what the government said. Government said that we are undertaking Bank Nationalization Act and we are overtaking these 14 private banks and converting them into government banks because we want to implement Articles 39B and C of DPSPs. Basically, Article 39B and C are the heart of common good. Basically, Article 39B says that material resources must serve the common good. Whatever the resources that India has, like land, mines, right, ores, forest, all these resources must not serve just the individual good, meaning they should not just enrich or help individual grow, but they should help the society grow. That is the meaning of Article 39B. And the government said that bank, if they are not nationalized, then they are giving loans only to individuals. We want to nationalize them in order to help maximum people to get money and grow, especially the rural areas, right? And what does Article 39C say? Economic policy should create equality rather than inequality. This is not exactly the words used. I'm giving you the summary. So government said that by creating bank nationalization, we are actually helping people to secure loans in order to bring equality. Now, what was the contention of the bankers who owned these banks in the RC Cooper case? Bankers said that Bank Nationalization Act first of all violates Article 14. Why? Because they said, why only 14 banks have been nationalized? What about the remaining banks? So that was their first condition, that government is discriminating only against these 14 banks. They said that government is also violating our right to profession. Right to profession is a fundamental right under Article 19, right? By not allowing us or these 14 banks to do banking activities, government is violating our right to profession. Their third contention was that government has not given us the just compensation which is required to be given under Article 31. Supreme Court in RC Cooper case struck down Bank Nationalization Act. So this was a big blow to Indira Gandhi government, which wanted to undertake social welfare programs. And in order to deal with the problem created by RC Cooper case, Indira Gandhi government amended the constitution in 25th Constitutional Amendment Act and inserted a new article called Article 31C. And this was the origin of Article 31C. Now let us see what does Article 31C say. This is the exact wording of Article 31C as it was amended in 25th Constitutional Amendment Act. Now currently this second provision is not there. Okay. Now let us see what it said in the beginning. No law that seeks to implement the socialistic directive principles specified in Article 39B or C shall be void on the ground contravention of the fundamental rights conferred by Articles 14 and 19. Right. Basically, government said that if the parliament or the state legislature is implementing 39B and C, then they cannot be challenged in courts for violation of Article 14 and 19, because they were challenged by the bankers in the Supreme Court under Article 14 and 19, as I just told you, right? What is the second clause of Article 31C said? No law containing a declaration that it is for giving effect to such policy shall be questioned in any court on the ground that it does not give effect to such a policy. Now, this was a problematic clause. Why? Because it basically took away the judicial review feature present in the Constitution. It is saying that, see, if there is an act passed by the Parliament of India or a state legislature, and in the beginning, if these acts are saying that we are implementing Article 39B or C, then that declaration was enough. Even if they did not implement Article 39B or C, they cannot be challenged in the court because they had already declared it. This was problematic, right? So, in Keshwananda Bharati case, which dealt with many things, Supreme Court struck this down, saying that basically judicial review is basic feature of the Constitution and Parliament cannot take this away. Okay, just because in the declaration you are saying Article 39B or C is being implemented through this act. So, after being struck down by the Supreme Court in 1973, now only this provision is remaining in Article 31C. Now that we have understood the origin and evolution of Articles 31A, B, and C, let us see them and understand what is the difference in a chart. Now, Article 31A and B were inserted through First Constitutional Amendment Act. Article 31C was inserted through 25th Constitutional Amendment Acts, right? What is the subject matter of Article 31A? Land Reforms and Nationalization Acts, right? Article 31B, which inserted 9th schedule, deals with any act. For example, recently, Jharkhand government's Reservation Act has been put in 9th schedule. Similarly, Tamil Nadu government's Reservation Act, which extends reservation beyond 50%, has been put in 9th schedule. Both of these acts are not dealing with land reforms or legislation. So any act can be put in 9th schedule. Article 31C, it also deals with two types of acts. Those acts which are implementing Articles 39B and C of DPSPs. So in the first case, 31B is very broad. Why? Because any act can be put in 9th schedule. Now, what is the second difference? Article 31A protects acts from being challenged for violation of Article 14 and 19 only. But Article 31B, when it was initially enacted in 1951, was very wide because it protected any act from being challenged for violation of any fundamental right. Article 31C, again, same as Article 31A. It also protects two types of acts from being challenged for violation of Article 14 and 19 only. This broad nature of Article 31B, as I told you, was clipped by the Supreme Court in different cases, especially IR Coelho case. So this is the present status of Articles 31A, B, and C. So I hope you have understood what is the difference and evolution of Articles 31A, B, and C. This is very important. If you have any doubts remaining, then please put them in comment section or in my Telegram channel. I will try to answer them as quickly as possible. So please subscribe and share the video, and until next time, take care.